On behalf of the Mecklenburg County Bar, thank you for selecting this recorded seminar for your CLE credits. The Bar depends on and appreciates your support. While we always love to see you in person at the Bar and Foundation Center, we know that this replay can be a real convenience to you by saving you some travel time and expense. For information on how to get more CLE credits with an MCB replay or an online course, check out our website at www.mecbarcle.org. We would also love to hear from you on any new ideas you may have for more CLE programming. Thank you again for supporting the Bar, and please enjoy the program.
Okay, well, welcome. I think it's time we can get started. I'm Tom Maher. I am the Executive Director of the Office of North Carolina's Indigent Defense Services. I take it, do all of you do court-appointed work? Who here does court-appointed work? Good. Well, we'll start off thanking you. In a moment, I'm going to introduce two of our commissioners who want to say a few words before we get into the meat of this. We've been asked to tell you that when you signed in, you will automatically get whatever certificate you need, I think, emailed to you. So rather than getting any kind of piece of paper at the end of the day, they're doing that electronically. For those of you who don't know, IDS is overseen by a 13-member commission of volunteers, of experienced lawyers who care about public defense. We're fortunate to have two of them were willing to travel here today, Mark Hollander and David Teddy. They both served for a number of years on the IDS Commission. They're both very active on the commission. We appreciate greatly the time and energy they put into that. So before we get into kind of the meat of what we want to talk about, I want to invite first Mr. Hollander, Commissioner Hollander, to come up and say a few words, and then David Teddy.
Thank you, Tom. My name is Mark Hollander, and I am a commissioner serving on the Indigent Defense Services Commission. And on behalf of the 13 commissioners serving on that commission, I'd like to welcome you to this CLE today on indigent policies and defense, appointment, billing, and other procedures. I practiced for about 25 years in private practice, and 20 of those years I was doing indigent defense work. I practiced in Cleveland County, where there is no public defender's office, so we got quite a bit of work from all levels of appointed cases, and I did basically every kind of appointed case that you could do short of capital murder cases, and it was a very important part of my practice, and I'm sure it's still an important part of the practice of the people here that take those kind of cases still. For your clients, you're often the only thing that's standing between them and a system that would steamroll right over them if you weren't there to represent them. And the role of an indigent defense attorney is very vital to the process, and the entire judicial system just wouldn't work if we didn't have people that were willing to take on these cases and do this work. I think a lot of people don't realize that all the kind of work that the IDS Commission and IDS itself is responsible for, there are a lot more than just the people who process your fee applications and send you your checks or put the deposits in your bank account. They set, the commission that I'm on sets the policy for private appointed counsel, public defenders, contract attorneys, all the offices of appellate defender, capital defender, juvenile defender, regional defenders, and lots of other folks. Also conduct continuing education classes like you're at here today, and other training classes, and have all kinds of training to cover all kinds of cases that would cover almost any situation. If you hadn't done so, I would ask you to go sometime soon and check out our website. There's a lot of good information on that website. There's a lot of stuff available if you're not aware, brief banks and sample motions and training materials that are very helpful, because we could all use help. Don't be afraid to ask for it. All the attorneys that serve in the positions that I just mentioned a couple minutes ago, they're all available to you. If you need help, ask for it from the appellate defenders, the capital defenders, the juvenile defenders, all those folks. They're glad to help you. And we've recently updated some stuff on our website, so we want to show it off and want you to see it and see what it looks like. So again, on behalf of the IDS commissioners, we want to thank you for all your hard work and dedication to indigent defense and welcome you to our presentation. And now, Mr. Teddy.
Good afternoon. I need everybody to stand up. Come on, stand up. Repeat after me. My name is? State your name. I am a public defender. I love my job. All right, you can have a seat. All right. Well, we're all defending the public and our clients. And I want to talk to you a little bit about it, the intersection of time and circumstance. I'll let that soak in just a minute. The intersection of time and circumstance. My sister's husband passed away in 2009 of pancreatic cancer at 46 years old. And she's been struggling ever since. And she's moving out of her house. And my wife's been helping her move. And my sister never throws anything away. So she ran across this note that was dated May 24, 1963. I just got it yesterday from my wife. Dear Shirley, that was my mom. Congratulations to you and Nuke. That was my dad's nickname. I kind of felt like you would have a boy this time. Now your family is perfect and complete. 2 darling little girls and a precious little boy. Guess I'll have to get busy now and have a little girl myself to go with my 2 boys. I wish I could. We'll write you a long letter later. Again, much happiness to you all. Love, Mary Ellen and family. May 24, 1963. I was born May 16, 1963. And the reason 1963 is an important year for you is because that is the year, March 18, 1963, that the United States Supreme Court handed down Gideon. And here we are, March 8, 2019. I'm 56. Well, I will be 56 in May, which means Gideon is 56. And Gideon started because Clarence was sitting in prison and decided to write a letter to the Supreme Court about the fact that he had been asked to defend himself for breaking into a pool hall. And the state of Florida said, and he wanted a lawyer, and the state of Florida said, no. You're not charged with a capital crime. You don't get a court-appointed lawyer unless you're charged with a capital crime. So he wrote a letter to the Supreme Court. And they treated it as I guess, a habeas corpus petition of some sort. And next thing you know, in 1963, Florida courts are reversed, and the right to court-appointed counsel applied to non-capital crimes. And so I tell you that story to basically try to impress upon you the power of what one person can do. And sometimes when you are a court-appointed lawyer and your client says, well, here comes another state employee trying to tell me what to do, you feel like you're kind of a voice crying in the wilderness. But I want you to know that I appreciate what you do because I do what you do in a little town called Shelby, North Carolina, about 40 miles west of here. And it's incredibly important work. And when you think about the intersection of time and circumstance, the fact that you got appointed to represent somebody or assigned to represent somebody is an intersection of time and circumstance in that person's life, but also an intersection of time and circumstance in your life. And so it's your job to figure out what your client's story is and to dig deep to find out what your client's story is. And I know y'all are out there doing it, and I want to tell you how much I appreciate it. Associate attorney in my office last night, getting ready for administrative court today in Shelby, was at the jail till past 11 o'clock last night, meeting with her clients, talking about the cases, not getting paid a whole lot of money to do it. But it is beautiful work, and I want to tell you how much I appreciate it. And I want you to think just a moment about I want you to think about if you ever get the feeling that what you're doing is either getting ground up in the system or you're not really making an impact, I want you to think about just standing by a pond with a rock in your hand and throwing that pond in the middle, that rock in the middle of that pond. There's a ripple effect when that rock hits that water. And that's what y'all are doing out there. You may not know it, but you're making a ripple effect in the lives of lots and lots of people. So don't give up. And be nice to your clients. Sometimes it's hard to be nice to them. But don't let the last thing that you say to a client be something short or mean. I've been short and mean with my clients before. Last Saturday, and I'm going to sit down. Tom didn't give me this much time, but I got some stuff on my mind. Last Saturday, I was down at Clemson. My son's about to graduate from Clemson. And went to the Carolina game. Carolina-Clemson. I'm actually a Carolina fan. I went to Tennessee, but I like Carolina basketball. So watching the game, and then I get a text from a friend of mine that the tennis pro at the club I belong to in Shelby, who was 59 years old, was getting in his recliner to watch the ball game because he's a big Carolina fan. 5:30, heart attack, gone, that quick. And so I got to thinking, I'd like to make a deal with God to at least have 2 weeks' notice to say some things that I want to see some people I want to see, to be kind to the person that I might not have been all that kind to a little while ago. And I've determined that you don't get 2 weeks' notice. So just remember that at the next intersection of time and circumstance. And I really appreciate y'all being here today and the work that you've done this week and the work you're going to do next week. Peace.
Okay, I want to thank both of the commissioners for coming. I want to echo their thoughts. I want to read you something real briefly. IDS in the last year decided we needed a formal mission statement. We're a very mission-driven organization. I think we all thought we had a mission, but we had to kind of come up with a statement. And part of it relates to a comment that was made about public defender versus private assigned counsel. In my background, I've never worked at a public defender's office. I spent a quarter century doing private practice, took court-appointed cases, but I'd never been a public defender in that sense. But our mission statement is safeguarding individual liberty and the Constitution by equipping the North Carolina public defense community with the resources it needs to achieve fair and just outcomes for clients. And I put that in the bottom of my emails, other people's do, partly to remind ourselves of what we're doing. But we had a very explicit discussion about what we do, and one of the things we believe strongly is that there is a public defense community. It includes the people we think of as full-time public defenders. You have a very vibrant public defender in Mecklenburg. It also includes all the private lawyers who do the work. You may not be full-time on public defense, you may be, but for us, you're part of the public defense community, and you are as important to your clients as the public defenders are to theirs, and as important to us. And on a more practical note, when I get calls from grandmas or mothers or wives or fathers about their child who is in jail and they want to talk about their public defender, they mean anybody who's working on the case. For the clients, you are all public defenders, and I think that's something to be proud of. I also want to address briefly, before I show a few slides, kind of our role and what I would ask your role. Our job is to give you the resources you need, and the reality is our current rate structure does not do that. We are finishing up an analysis of what we call an overhead survey. Some of you may have participated in it because I bugged you with constant emails, and if you did, we really thank you. But the numbers are disturbing. 8 out of 10 of you don't have retirement accounts for doing this work. We have people doing this work who don't have health insurance, people who make $10 an hour doing it, out of which they have to pay for health insurance. So you are not getting the resources you or your clients need. And that's why there was, and I hope most of you were able to get it, what we call a one-pager at IDS about the urgent need to restore PAC rates. And the reason we passed it out is, you obviously, if you do this work, you don't need to be told, but we try to provide some speaking points and data. And what we ask you is to speak out. Speak to your legislators, speak to other legislators, speak to your community groups, write an op-ed. The reality is most people in the General Assembly, if you approach them and you explain this, will say, yeah, Tom, we know, you've got to pay them more. And then they will say something like, you have to do it with your existing budget, and the math just doesn't work. Or you need to be patient. And of course, you can't be patient, your clients can't be patient, it needs to be addressed now. So if we don't help make it a priority by kind of speaking out, we will continue to get steamrolled on this issue. So that's why that's there. The other thing that's there, hopefully there's still a pile of them there, as a booklet called In Prison. And partly I think it's useful for those of you who represent clients who may in fact go to the prison system. It is a publication from the School of Government. It is not a comic book, it's more like a graphic novel. It is, I think, actually very well done to explain to people who may not be, JDs or PhDs or even a bachelor's degree or high school diploma, what it means to go through the prison system. If this is something that's useful to you and you want more copies, contact me, we'll get you more. We have other books we try to hand out. It is as close to bling as IDS has. And it reflects one of the things we work on that I'm going to address briefly before turning this over to Elisa, which is trying, in addition to fighting for money to pay for you, trying to find ways to directly help you gain knowledge and experience and resources. So when you are dealing with your clients, you're not alone. So I have to turn this on, probably. Okay. Okay, so we don't, as I said, represent clients. Clients often call, they expect that we do, but we don't. But we do, as I said, work hard to provide resources for you. And it always kind of surprises me that we don't do a good enough job of letting you know the resources that are out there. So I want to show you a few of them. We do have a website. We're in the process of coming up with a new website, which, because of Mr. Teddy, will have a picture of me that actually reflects my current age, not my age at age 30. And one of the things we have is Forensic Resource Counsel. A number of years ago, we realized that scientific evidence pervades the justice system, from a DWI or DNA in a small case to much more complex forensics. And most of us went to, at least if you're like me, went to law school because we didn't deal with science, otherwise we'd be doctors. So we developed this position, Forensic Resource Counsel. How many of you have ever gotten information or help from our Forensic Resource Counsel? One. Okay. How many of you, until I just said that, didn't even know we had a Forensic Resource Counsel? Yeah, we need to do a better job of letting you all know this. Forensic Resource Counsel can help you identify experts, and her name is Sarah Olson. She's a great person. She will consult with you on issues including reviewing discovery if you need help on that. She puts on trainings that are designed for lawyers like you doing this work. If you go to our website, the current website, and you go there, you'll see a link. And if you press that link, it will take you to her page. And on her page, there's a database of experts. There's online trainings. There's all sorts of information. If you call her, she will answer her phone and talk to you. She will talk you through the issues. She will help you find an expert. She will help you understand the discovery, whether you got it all, and what it means. So if you have a case, and it doesn't matter whether it's a murder case or a misdemeanor, and it has scientific evidence you haven't dealt with or you don't feel comfortable with, contact Sarah Olson. She's there to help. We also have other resources. One of the things that you may be aware of course, is that the U.S. Supreme Court requires that you give at least basic, competent immigration advice to clients who may have immigration consequences for this. And immigration law is one of those things that if you know a little bit about, you can be incredibly dangerous. In our world, the world of adult criminal representation, a deferred prosecution that results in a dismissal is not a conviction. In the world of immigration, if you admit to the act in the course of getting a deferral and it's dismissed, you are convicted of that crime for the purposes of immigration. And so it is an incredibly dangerous thing to give advice on. So what we have done is create an online resource for getting immigration advice, immigration consultations. Once again, if you go to our website, you'll see the immigration consultation. If you click on there, a page will come up that gives you several options, one of which will take you to this page. It is an online form. You fill it out with basic information about your client and the case. You submit it, and it goes to one of two experienced immigration lawyers we have who will get back to you with advice about what would happen if your client was convicted of that, what would happen if you got some other result. We ask that you try to get it in as soon as possible. Don't wait till you've got a plea offer on the table and a trial starting. And if you've got a client who may have immigration consequences and you are not an immigration attorney, this is available for anybody doing court-appointed work. I don't know, how many of you knew it was available? How many of you didn't know? How many of you now, if you have a non-U.S. citizen client, will use this? Good, thank you. Those are not the only other resources. Go to our website. They're the rules, the policies. We're going to be talking some about them, but they're all up there. We have a system called eBlast, which I urge you to sign up for. It is a one-way communication tool. We let people know about legislative stuff, but other announcements. A lawyer I know said, so this is a one-way tool where you can send us bad news and we don't get to complain. Yes, that's what it is. You can sign up on our website. There are links to our specialized defender programs. We have the appellate defender, the capital defender, the juvenile defender, and Office of Parent Representation, special counsel. They all focus on specialized case types. They will all talk to you if you need help. If you are representing somebody and there's a legal issue you have not been able to think through on your own, call the appellate defender. They have a lawyer or two on duty every day to answer questions for trial counsel. If you have a question about a murder case, call the capital defender, even if it's not a capital case. Same with the juvenile defender. They are a resource for anybody representing children in the system. Parent representation, special counsel. Please call them. There are other things. The School of Government offers trainings, there's blogs, there's publications. If you haven't gone to their site, and there's a link to their site from ours, it is really useful. There's brief banks, there's motions. The blogs, are an update on recent criminal law developments. And then, of course, there's a number of associations. And I will say the associations provide not only training, such as the Advocates or the Bar Association, they are also try to provide a voice for you in the legislature. So, if you are a member of the Advocates or a member of the Bar Association, let them know that you care about public defense. You care and want them to lobby for public defense. I don't know to what extent, your local district bar gets active. It'd be great if they would. If the local bars would speak out and tell legislators, this is a priority, and it's a priority not just for the lawyers who do this work, but for the justice system and for everybody. Okay, Elisa Wolper, many of you may have dealt with her. She's always happy to answer questions, and here she is to talk about indigent policies. And I don't know whether if you go here, you'll see the...
Oops. Okay, I'll give up. Okay. This is a redo of a video we did a number of years ago that on sort of some basic issues about doing indigent defense work and the billing procedures and what hours counted. And we looked back at that and found that the issues sort of had changed that we felt were important to communicate to people either thinking of or doing court-appointed work. And one of the sort of the basic issues is, when are you appointed? What's the sort of first step in being appointed to a case where there's an indigent defendant? And there's not a hard and fast, unambiguous definition of indigency. First of all, it's a point in time. Someone can have a job, can have assets, but they're in a place where they cannot afford to hire a lawyer or have access to their funds to hire a lawyer and can have an attorney appointed. We've learned that across the state, different counties have different perspectives on indigency. We've heard in some counties, if you have a job, that the court won't find you indigent for purposes of appointment. There is a form, a statewide court form that many counties use. Some counties have variations. So there's been discussion about having both guidelines and more uniform policies, but it is still a decision that's going to be made in that court after the client has filled out some affidavit of indigency, either with or without assistance. So like many things in indigent defense, it's a mixture of county and state procedures. And there's talk about making it, as I said, making it more uniform, but you have to know your own local things. So I get questions all the time from attorneys about how do I find out this or where do I put my fee application? And I said, you need to ask one of your local attorneys because we can't keep track of all 100 different procedures of paper flow or anything else. And so in some counties, there'll actually be an administrative rule that will detail things about billing or appointment and other things, and that when we get copies of those administrative rules, we'll put them on our website, but we certainly don't have them for every county. And every county is supposed to have an indigent committee like Mecklenburg does, and we understand that having this CLE or some variation of it is part of the requirements here in Mecklenburg, but there are counties where we have not been able to locate the existence of an indigent committee. If you are appointed, even if there's been a determination of indigency in the courtroom, there are still two things you need to check before you proceed. One of the least favorite things of my job is when I get a fee application from an attorney who has represented someone, but I can't pay it for a variety of reasons. And sometimes that's because, although there was an initial determination of indigency, because of some specifics, there was really not entitlement to counsel in that case, and that they can't. And so that if there wasn't entitlement to counsel, we can't pay it. And so we're going to talk a little bit about some of the potholes in that procedure where it would appear that there's entitlement to counsel, but there in fact isn't. And the other thing, of course, is a conflict check. Sometimes we get fee applications where there's a lot of hours in before it's determined that there's a conflict in the case. And so we encourage that to be early on in the process. First thing is murder cases. We use the term in our office capital cases or potentially capital cases. And if it's a first-degree murder charge and the client is 18 or older, we consider it a potentially capital case for the entire life of the case. So even though you might be appointed, or a trial judge might be appointing you to a case that everyone assumes will not proceed capitally, if it started out at that first moment as a potentially capital case, the entire procedure is under the Office of Capital Defender. They appoint the counsel. They have a specific roster of qualified individuals. If there's any requests for experts or other services, they have to approve that. And the fee application does not go to the judge who presides over the trial. It goes to our executive director and in our Durham office. So there's a whole different procedure. And attorneys get caught by that a lot because but when they were appointed, everybody knew it wasn't going to go capital, and so they thought it was a regular murder case, non-capital murder case. So that's one thing to determine early on. The other thing, which is a more recent issue, is that entitlement to counsel, of course, is based on the potential loss of liberty or a fine above a certain amount. A number of years ago, the legislature took a lot of low-level misdemeanors that we and others had been advocating should be decriminalized and become infractions, which would have meant non-entitlement to counsel, but they left them as crimes, but reduced the potential fine so that unless there was enough prior convictions to put that defendant in the category of facing an active sentence, there is no longer entitlement to counsel. And the big examples were driving while license revoked, not related to DWI, shoplifting without priors, and possession of both drug paraphernalia and low levels. So in those cases, I see dozens a week where an attorney's been appointed to the case, but because it was a Class 3 misdemeanor and the defendant did not have at least 4 prior convictions, we can't pay the fee application. The prosecutors and others in the courtroom have an ability to check prior records. Defense counsel don't have access to that tool to do it, but we know there, particularly if you're trying to look statewide, but it is something to be aware of if you know the only charge your client is facing is a Class 3 misdemeanor and they don't have a prior record, even if the judge has appointed you using the AOCCR 224, you need to double check on that, or you run the risk of submitting the fee application and not being able to be paid. We very much appreciate when people do work pro bono, but we prefer they know it's pro bono before they do it. So that's one of the bigger pitfalls. And we've spent a couple of years outlining the problems that arose from that and trying to talk about ways. And what we really meant was decriminalization, not just taking away right to counsel. And those, of course, many attorneys we talk to, see that first Class 3 misdemeanor as the slippery slope, and where effective counsel at that time, even if the person doesn't have prior records, can make a big difference in the future. But we're bound by the restrictions in the law as to what we can pay for. One of the other places where there's pitfalls is parent representation and other civil, usually where judges will often want to appoint a GAL in a case because the client has needs. But there are really very restricted areas where IDS can pay for a GAL. For GAL for respondent parent can only be, is only appropriate if there's a need for a substitutive as opposed to assistive GAL. A number of years ago, there would frequently be GALs appointed for a respondent parent if there was any kind of issue that led to the allegations of abuse, neglect, and dependency. And so that could potentially be almost every parent in DSS court. And so there was some review of those and new policies that say it's only if there's a need for a substitutive GAL, and that there need to be specific findings from the court as to why there is a need for a substitutive GAL. It can be because the respondent parent is themselves a minor, or it often has to do with specific findings on either mental health or mental capacity. And so that if we get a fee application for a GAL for a parent respondent and there isn't a document that details the court's findings, we also cannot pay that. So that's one of the pitfalls. The other place where we see problems is judges appointing GALs in delinquency court because the child needs someone to advocate for them, but GALs for juveniles are handled by the actual GAL program, and that's only if there's an actual petition from DSS. And so it's not something that falls under IDS's umbrella. We do pay contempt charges. This is sort of the flip side where people say, oh, IDS pays that. There can be civil matters that, as you all know, that develop into contempt charges. And so even if the underlying issue was a civil, perhaps a domestic issue, if it has come to the point of either civil or criminal contempt, that is a fee application that we get either on the civil form or on the criminal form. Technically, the clerks are supposed to take out a criminal file number if a civil matter turns into criminal contempt, but we know most don't do that, and so that we get those billings with that original civil file number. That's one of the other little quirks. There are a couple of unusual issues that arise after you've been appointed. One is sometimes you've been appointed to represent someone, and they or the family member may ask if they can retain you. If you've been appointed by the court pursuant to the finding of indigency, you can't then have that party retain you. However, those individuals can ask if they can we hire an expert or can we pay for an evaluation? Those things are allowed. Those kind of quirky questions, I mean, we wanted to mention them as the kind of things that you need to have in mind, but those are probably good things to check with us on because every situation is a little different. So after you are approved, probably one of the most important things is IDS rules require that if your client is in custody, that they be seen within 3 days. Mr. Maher, of course, gets lots of phone calls from people unhappy with their situation, and often it is, I haven't heard from my attorney. I never saw my attorney and didn't see my attorney. And so that's a good rule of thumb. And also early on in the case, we talked at the beginning of this about some of the resources that IDS can channel you to. That's a good thing to think of early in the case. In terms of the use of outside experts or private investigators in court-appointed cases, there is a lot of that. We found it varies tremendously from county to county. There are counties where most cases the attorneys have been able to retain the services of an outside private investigator, and in some counties where it almost never happens. So it's at the judge's discretion. And the procedure for that is a motion to the court, and then there's a form, this is the AOC G309, where you detail what kind of expert you want. The form actually sets out the hourly rates for that expert, which are where we start, and where you sign it, and where the judge uses that as the court order for you to be able to use an expert, and then the expert in turn uses that as part of their billing. The rule is that if you are using an expert or any kind of outside service with your case, that you're not to pay them yourself and then include that on your fee application, that they're also being appointed by the court to be paid directly by the state. And so that, I wouldn't say it never happens, but the preference is that they bill us directly. We have the proper documentation, know they're using the proper form, and pay them. Of course, in the course of the work, you may have to advance some expenses. I mean, little things like printing and postage, or sometimes paying for records, and those are things that you can include on your fee application. Again, it's at the discretion of the judge, but I don't think we almost ever see that not allowed for when you're billing. Travel. Let me see. Okay. Talking a little bit more about how you're paid. Most in trial court, non-capital cases or non-appellate cases, most cases there's a single billing at disposition on a final fee application. Our rules allow interims. Again, that appears to be something that varies from county to county. I think some attorneys don't want to mess with interims, but certainly if there's a case that's going to drag on a long time, some attorneys submit interims at a point where there's a call and fail, not knowing whether there's going to be additional work in the case. Again, that's at the discretion of the judge, but is allowed. But our rule of thumb, when people say, how many cases did you handle, we count how many fee applications we paid, knowing that's a slight overestimate because some of those are interims. And there are different fee applications, and they differ in a couple of ways. I think I'm going to have to move a little bit. You did better with this than I did. I apologize. Okay. This works, I think, as long as I'm still being taped. Okay. So the way you bill is not sending a bill. Many of you who have retained clients have billing systems and timekeeping systems, and so you're not sending your regular invoice. You can include that as an attachment, but you're billing on a specific IDS form, and it's completed by you. The fee is authorized by the trial judge. It should be the presiding judge. We have instances where the presiding judge is not available. The chief district or senior resident can do it in lieu of them. Some will, some won't. And then that's sent by the clerk of court to our offices in Raleigh. We don't accept fee applications directly from attorneys. If we do, we send them right back. The clerk of court is sort of the chain of custody in that fee application. The exception is appellate fee applications, and those are for non-capital appellate cases. Those are sent to Raleigh. They're reviewed by the appellate defender's office there, and then the fee is set by the IDS director. And potentially capital cases, those fee applications also come to our Durham office and are reviewed by the IDS executive director, and the fees set there. So those bypass the clerk's office altogether at that point. The final ends up in the clerk's files, but they don't come through the clerk's offices. Our offices in Raleigh, where we process fee applications, we get mail from all 100 counties every week with sets of fee applications. This from Mecklenburg. Every Tuesday. And then the payments are actually issued by the state. They are done by the Office of State Controller. Payments sent directly to you either by a paper check or electronically. The administrative office of the courts assists us with processing those, but the actual handling of the fees is done by the IDS Financial Services Office. Okay. There are different forms for different kinds of cases. The non-capital trial form, the civil form, the delinquency form, and then forms for capital and appellate work. Those forms vary in part because they ask for different information, And then also the language on them in terms of the judgment against a client or another party are slightly different. And so there's an important reason that we use the different forms for the different kinds of cases. And we'll sometimes have to send a fee application back if it's on the wrong form, given the kind of case. The forms get updated periodically, and so we do need you to use the most recent versions of the forms. And those are always on our website on a link, and the clerk's office should be aware of the forms. The rates. When I first went to work for IDS, all cases, non-capital cases, were paid at $75 an hour. When our funding was drastically reduced in 2011, we went to a tiered system because otherwise we would have had, it was in order to preserve at least some semblance of a reasonable rate for the higher level cases. And so now we have a situation where our rates actually range from $55 an hour for most district court work to $90 an hour for capital trials. And those rates have changed twice in the past 12 months and will hopefully be able to be changed again. As we've been able to secure some additional availability, we've been able to do some very targeted rate increases and have a major push right now to actually try to restore our rates to what they were in 2011. I left a handout in the back. It's a chart that's on our website, easy to find, which are the current rates. And so you should, because I'm actually hoping that the rates will change again in the 12 months because we would like to increase them further. It's not something that I would want people to rely on what we're saying today, that it should be checked. We do communicate with attorneys in lots of different ways when the rates change, as well as with the judges and the clerks, but it is something to be aware of. And when our rates change, they're often based on a specific date. When we increase rates, we do it based on disposition date, because that's fairly easy for everybody involved to know. When we had to reduce rates, we did it based on appointment date so that we weren't retroactively reducing a rate. So our most recent rate increase, which I feel like hasn't totally been absorbed statewide, is we increased the hourly rate for low-level felonies in district court, including delinquency court, to $60. So now low-level felony rates are the same whether it's district court or superior court. And that was effective with dispositions December 1st or later, and we are still having to return way too many fee applications because attorneys are using the old lower rate. And so we're trying to get that spread through. The other thing to keep in mind is we have a deadline within the fee application needs to be submitted to the judge within 1 year of disposition. Sometimes fee applications go missing after they've been submitted on their path from you to the judge, to the clerk, to our office in Raleigh. That isn't a deadline issue. That's just sometimes we'll tell you to have something resubmitted. But your initial submission is within 1 year, which is why your signature on the fee application needs to be dated. Expenses, I talked a little bit about that. It's not unexpected that you have incidental expenses, and frequent one is copies. We can pay for out-of-county mileage, but not within the county. That applies both to our attorneys who are public defenders on salary and to court-appointed counsel. And there are a few other things that, in those very specific rules on expenses are on our website. Don't change often, but it is always good to reference the rules on our website. I wanted to emphasize that the fee application, we have our example, this is an older version, serves two purposes. It's your bill. It actually serves more than two purposes. It's your bill. It's also the main way that IDS has any information about what's happening in the field, how long cases take, what cases are being handled by court-appointed counsel, how many Class G felonies, how many A1 misdemeanors, trial rates, frequency, withdrawals, everything. Anything we would need to know in order to look at issues in the system, the cost of what we do, the potential cost of trying to do more is all dependent on the information we collect on the fee application. It also has a very important legal purpose, which is it's the written document for a judgment against the client if convicted for the cost of their court-appointed attorney. And so in the clerk's office, it's a very important document that moves from the criminal division to the civil division where they're going to be docketing a judgment. And then because it's a legal document, we run into this. Sometimes we have to send it back for correction or completion. If the judge has signed it, only the judge can change the items that the judge has signed off on. And so that's why we're often saying you have to give it back to the judge to change the award and then have the judge initial it, because we're treating it like a legal document. One of the biggest sets of pieces of information you'll need to complete a fee application is dates. And we actually ask for 7 different dates. And each one has an important function. We ask for your appointment date. That sometimes affects the rates, but also affects our research on lag times between how quickly cases are disposed of. We ask for your date of the first substantial contact with the client, whether it either be direct contact or by phone. We need both your starting date and your ending date, and that's your billing. The fee application that you're submitting, what's the time span it includes. And we need the disposition date if it's a final fee application. We often use that to match with criminal data, but we actually use that as the invoice date in our system, and it's the best way we track different things. And we ask you, when you sign the fee application, you should date your signature because that's your date of submission. And then when the judge does the award, that date is also recorded. That doesn't always happen. The other category where we ask for a lot of information is time. We ask for your time out of court, your time in court waiting that's not actually working on the specific case, and your time in court on the case. For time out of court and time in court waiting, you may be traveling or at the jail for multiple clients at the same time, multiple cases, and our expectation is that your time be prorated. If you sit in court for 3 hours waiting for your cases to be called and you're there waiting on 3 cases, then you would put 1 hour on each of the 3 fee applications. Timesheets. IDS does not require timesheets. We like seeing timesheets. Many counties have local rules requiring timesheets for over a certain threshold. I'm not sure what it is in Mecklenburg right now. Is it 10 hours? That's what we often hear. Any judge can ask for a timesheet, and we presume that attorneys are keeping timesheets, but whether they're attached to the fee application is, again, up to sort of local rule. A few things about what time can be included. Time spent preparing a fee application cannot be included. Time traveling for another county just to file a document, if there are alternatives, is not included. That's in our written rules, so it must have come up in the early days. I haven't seen that one come up that so much recently. And there are some more sort of fine rules about dealing with discovery and copies that are on our website, and I think I'm going to not necessarily talk about them here. One thing we did want to mention is we know that discovery has become an increasingly significant part of your work and also a increasingly time-consuming part of your work. And of course, we hear this from our defender offices, which they gave me the videos from all 7 body cams, and it's going to take me a week to review them. And we've been working with our defender offices to see if there are any technological tools that could be helpful. I mean, so it's an issue that we're aware of, that, due diligence requires a lot of time to review that discovery. So we just sort of want to mention that we recognize that as something that can increase the out-of-court time that you would see on a fee application. If you receive your discovery in electronic format and feel like you need to convert that to hard copy, either to go over with your client, that is time that we recognize is part of the time on the case. Okay, information on the fee application. Every blank is there for a reason and is required. I'm not saying we send back every fee application that's missing anything, but if it's on there, we really have a reason for wanting it. Probably the most complicated thing on a fee application is the box where we ask for the file number. Most fee applications will involve more than one charge in more than one file. And so we needed a convention that was unambiguous for our system. And so we asked for the lowest number in the highest court. So if you have a mixture of district court and superior court file numbers that were resolved in superior court, we would want the lowest number that's a CRS file number. And then we ask that you list the additional file numbers on the fee application or on it. Every once in a while it requires an attachment, but it's that lead one that we want next to the caret right here. That's our convention for that. And we recognize that's not always the lead case file number, either for the highest charge or for what the clerks are using for the file.
If you want that lowest case number, like I usually associate it with whatever they're sentenced under, I usually.
Yeah, yeah. And we understand that in your files, you'd say, this is the file number for this kind. But for our system, we want that lowest file number. If there's only one file number on the fee application, that's not an issue. And that's been the complicated thing about our fee applications is it's sort of like filling out a tax form. You sort of have to sometimes check your common sense at the door and just follow the steps, do the TurboTax. And so, you know, the file number is the lowest file number. The first column is the highest charge. The second column is the most serious disposition, which isn't necessarily the highest charge. And the third column is the judgment and sentencing.
I have a question. Is it okay to do a range in that, or do you want only the first, like the lowest number?
Yeah, a range is okay, because we can pick the first one as the lowest number. Legibility helps. We wish that we had an electronic system, and my staff does spend a lot of time trying to decipher the undecipherable. Particularly judges' names is the hardest thing, and so, but we know that isn't the system right now. The other sort of key issue on fee applications is many of you can be representing a client on a long list of charges or several charges, offenses that occurred on different dates, cases where you were appointed on different dates, but if they are all resolved together in the same court on the same date, they should all be consolidated on a single fee application. There are a few very specific exceptions, but that's the general rule. And we recognize that attorneys often don't want to do that because their client was acquitted on 4 charges and convicted on the 5th. Their timesheet includes time both on the acquitted charges and the convicted charges. If they're convicted, the judgment is going to be on the total. And although we recognize that concern, our consolidation rule is very important. It is possible for judges to order judgment separate from the full fee application. I don't know how often that can happen in a busy courtroom, but we have to stick to our consolidation rule, recognizing why some people don't want to do it that way. And signatures, of course, are important. I call it the fatal flaw. If it's missing your signature or the judge's signature, there's nothing we can do but send it back. When we have incomplete fee applications, we return them to you via the clerk's office. I know there are mailboxes up by the judge's offices in the courthouse in Mecklenburg, and they're left. I think they're left in a basket for you there. And so we know it adds a lot of time to your payment, but we return it back to the clerk's office. So if you haven't been paid on a case and you're wondering why, it's always worth checking to see if it was returned to you because it was either missing a signature or had some other problem with it. The other thing to clarify on the fee application is you're the applicant, you're the one who was appointed, and you're the one who did the work on the case. We do know sometimes attorneys can ask somebody to do something very limited for them, like, I can't be in courtroom 3A today, will you stand up and say such and such? But the substantial work on the case needs to be only done by the applicant. The payee may be someone else. If you work for a law firm, you can be the applicant and the payee can be the law firm. And so we recognize there can be 2 different entities involved, but want to clarify the different roles. And your tax ID number, which is your vendor number in the state accounting system, is a crucial part of the fee application. Many of you use your Social Security numbers. We're not forbidden to use that as your tax ID number. We're discouraged from doing that just because of concerns about identity theft. And you can get a free tax ID number from the IRS, and we encourage you to do that when you can. Our office in Raleigh, there's a listing on our website. It divides up the counties among our 4 staff who process fee applications, and so you're welcome to call directly the person who handles Mecklenburg or their supervisor or myself. I didn't list the names because sometimes those things change, but that's a good place to look on our website. Emails are great. Our staff spends a lot of time answering questions from attorneys about their fee applications. Then just a word about recoupment, because I realize we're almost out. We know that the idea that your client who has been found indigent but is convicted now owes the state money, which they may not have, for their cost of their court-appointed attorney is something that philosophically we all struggle with, but it is the law, and a not insignificant portion of IDS's budget approved by the state is based on recoupment from clients, either through what they pay in the clerk's office while on probation, or if it's docketed as a civil judgment, from intercepted state tax refunds or lottery winnings. And so because of that, obtaining your client's Social Security number is part of your obligation. I know it's not something, again, I know there's some discomfort with that. You can, and usually the Social Security number, or often the Social Security number, is on the affidavit of indigency or elsewhere in the court file. Clerks can assist with that. They can actually contact our staff in Raleigh who can help them find a Social Security number. Sometimes clients don't have them, or there just isn't any way to find them, and there's a box on the fee application where you can say could not obtain or unknown, but we do know, but we do expect some effort in that because it is the system. But again, on recoupment, your client has a right to be heard, to be told what they owe, and to be heard on it if they choose to. And there's been a series of recent appellate court decisions that have, where clients said, I was never given an opportunity to comment on my attorney's fee, and those cases have been sent back for that purpose. And so do be protective of that right of your client. And so that means that when you're at disposition, the judge will ask, how many hours do you have in this case? And so even if you don't physically have your fee application complete, you should be able to tell the number of hours because that's the client's right to know that that fee application, which will be used as a vehicle for docketing a judgment against them, how large it is. So ideally, you have your fee application ready at time of disposition, or at least know the total hours. I know a lot of years ago in Charlotte, it was required, and so attorneys would have it all ready except for that court appearance and then add that last thing.
I was going to say it is. Superior Court has been for years. Recently, District Court has also, except in cases of dismissal for FTAs, because it's not a recruitment issue there.
So this reminder might not be as important here in Charlotte. And then just, after your fee application is submitted and it comes, the original stays in the clerk's file, and then often there's a copy. I know it varies from county to county about how many copies you submit or whether they make the copies themselves, but there's usually a copy that goes to the civil department for docketing, one that's kept in the SHUC or the court file, and then a copy that's sent to us in Raleigh for processing. After we process it, we image it. We don't keep the paper copy. We image it. We store them for about a year, the paper copies, and so it lives on in our imaging system. And so we can be asked, can you pull a fee application from 2012? And we can do that. So it lives on forever. And we try to pay within 2 weeks. It's usually faster. Sometimes at the end of the year, we've unfortunately had cash flow issues when our budget's exhausted. This year, that may happen in late June, but generally we try to turn things around pretty quick. And we put on our website what days we're processing. It'll say, during the week of March 11th, we're going to make payments on the 11th, the 13th, and the 15th, and pay fee applications received between March 1st and March 8th. And so that gives you some ideas to where we're processing. There's some information on retention of case files that I think we're probably out of time to leave time for a few questions. It's just that IDS does recommend some more stringent retention of case files than you would otherwise hear just in general for purposes. And there is some information on our website that we encourage you to look at. But I did want to leave a few minutes for questions. Just get to do our graphics before we start. So if you have questions for either of us.
Any questions, comments? Yes.
I have a question about the policy on review hearings. Most frequently, 15A and 9096 conditional discharges, and often for DWIs, there are review dates that the judges expect, obviously, counsel to be present for. And I thought at one point in time there was some policy from IDS about billing for those.
Yeah, and at some level, obviously, a judge decides to pay you, we're not going to kick it back. But I think there are some differences. For example, if you've got a deferred prosecution and it's not dismissed until completed, the case is still pending, and if you show up on the compliance date to make sure it gets dismissed, that's part of your representation. 9096, a judgment may not be entered, but there's going to be a decision at the end about dismissal. I think you're probably justified in continue on the case. But what we increasingly see is somebody's convicted, they're put on unsupervised probation with monetary penalties, the case is over other than them paying it, and the review date or compliance date is set where they're supposed to come back to show that they paid whatever amount. We do not believe they're entitled to counsel for that hearing. What is supposed to happen, and I will say, I understand the concerns, but is if they haven't paid, then a decision is made whether to have a show cause order or to deal with potentially revoking probation, but nothing is supposed to happen that day because the case has been disposed and they're just there to confirm they paid. If a judge requires you to be there, then you're there representing the client. We're not going to tell you to avoid a judge's order. Personally, I don't think this is the best way to check up on whether clients are meeting their financial conditions, to make them miss another day of court or childcare and come in just to check in. But if that's the system and the judge says you will be there, then wait till then to submit your fee application and include that time on that. I'm not sure on a technical matter that they're entitled to counsel because they've already been sentenced. And they're just coming in to show they've complied with their sentence, unlike a deferral where the case is still alive until they've completed and it gets dismissed.
So if the disposition date is before your ending date, then there most likely won't be issues as long as it's been assigned by the judge.
Yeah, if a judge says I've determined that your obligation to the client continues through this compliance date, well, I may personally disagree with him, he's or she is the judge, and we're not going to challenge that. I think they're wrong if this is a unsupervised probation, is purely financial compliance. They could have them go check in with the clerk's office or do something else, but they've chosen to set a court date for a case that is actually not pending at that point. Other questions? Yeah.
The last time I heeded your advice to speak to my legislators about the importance of indigent defense, I got the sense that there was this growing sentiment to move toward a model of flat fee per case. I'm not talking about the bids in some counties. I'm talking about
Right.
You get appointed to this. Where are we with that? Is that dying out?
What happened with that was a couple years ago at the Senate level, and a particular senator thought that paying by the hour was a bad idea. And so we were directed to pilot test fee schedules for district court cases, not superior court cases, in 6 counties. Mecklenburg was specifically excluded from being a pilot because it's too large to pilot test things. I don't like flat fees. I like the contract system better, but it has issues. But flat fees I don't like, but they told us to do it. So we picked 6 counties. They included Macon and Watauga as small counties, and then there were 2 medium counties and 2 larger counties, and that went into effect about 2 years ago. We came back with a final report where we suggested that the counties be allowed that were picked to ask to opt out. And surprisingly, that recommendation was approved. And so the legislation was changed so that counties that were picked and were participating, if the Chief District Court judge made a request, AOC could determine whether to let them opt out. Macon and Watauga were the 2 counties that asked to opt out. And I think flat fees, in my mind, are problematic, particularly given how low they are right now. I charge flat fees as a private attorney, but they weren't $185. So, and in Macon and Watauga, the caseloads are relatively low. They're multi-county rural districts. The lawyers have to travel, and particularly in Macon, but in Watauga as well, it was a problem. So they both asked to opt out, and a couple weeks ago, Judge Warren, before he left as AOC director, approved them opting out. So 2 of the 6 have opted out. The other 4 have remained. There is no legislative requirement that we expand it at this point. So we've got 2 counties, Cabarrus and Rowan, which have done it historically. They did it before IDS got created. And then these other 4, there's no push at this point to make us expand it. And if there is, and one of the benefits, I will really urge you to sign up for the e-blast if you haven't already done so. If stuff like this comes up, our best way to communicate with the private bar is on our listservs. Either we have a capital listserv and an appellate listserv. I communicate on the Advocates for Justice criminal listserv, but a lot of you are not on that. So if you're on the e-blast, we can let you know when there's an important legislative issue pending that may affect you and your clients, and you could speak out on it. But at this point, I'm not aware of any push to expand that. And the particular senator who was in favor of that lost her primary last year. Yeah, it's a shame. And she's not here anymore. And I will say that's what happens. Our contract system was pushed by particular members. They left. And then other people wanted flat fees. She left. So we tried to be proactive, not reactive, but we don't have total control over that.
Thank you. Bob, could you just bring folks up to date about the lobbying effort on the private side counsel rates?
Yeah, we have been, and we are asking to increase the rates by $15 an hour from what they were when they got cut in 2011. So if it's $55 an hour in district court, it would go up to 70. That is not what it was before the cut, but it is a significant step forward. Same with the other rates. That is a significant ask for money. It's about $17 million a year. We asked the governor for that. We're asking the General Assembly for that. The governor has recommended, they were very sympathetic. We get a lot of sympathy, but they said they didn't have the money, so they recommended a little over $2 million the first year, and I think the idea is it would be whatever increase would be put in halfway through the year, and then $4.2 million the second year. If we got that and we got nothing other than that, we would obviously find some of the rates to try to raise, but it would not be $15 an hour across the board. Our budget is largely controlled by the Senate and House JPS appropriations subcommittees, what we call JPS. And if you've gotten any emails from me, there's always links to the members there. They are actually pretty good committees this year. We have Danny Britt, who's in addition to being a Republican legislator, is a private lawyer in Lumberton who does court-appointed work. We had David Rogers on the House, a second-term Republican who does court-appointed work. We have other lawyers, Joe John, Billy Richardson. There's a number of people who understand what you do. Some of them do what you do. I think they're open to this. They need backing. They need to hear that it's a priority because we've got significant money being asked for raise the age implementation. Giving state employees even modest raises costs a lot of money. The schools want more money. Everybody wants more money. So keeping the priority up is important. And so I really urge you, contact your local legislators and contact everybody on JPS. If you don't already get the emails from me, sign up for eBlast. I will send them out. They will get links to everybody on that. We are working with some outside folks to help us develop a more effective storytelling, so to speak. But what really matters in the General Assembly is what's the priority. If they had all the money in the world, we'd be paying you a lot more. But they don't, and they have to choose. So they need to hear from their constituents that this is an issue that their constituents care about, and you are the constituents of the folks from Mecklenburg. We actually have, although he's not on JPS, you have a state senator from Mecklenburg who is an assistant public defender, Senator Muhammad. He is not on JPS, but he is in the General Assembly, and he obviously understands this. But it would help even him to hear from you about how important it is. And I assume most of you are private lawyers, right? I mean, you do incredible work, and you are, unless you are independently wealthy or have a great retained practice, you're struggling. And that is bad for you, and it's bad for the clients. It has gone on for 8 years since we cut the rates, and it really needs to end. And telling us to be patient, they'll get to us when they get to us, just isn't working. I mean, in Mecklenburg, we're lucky we've got a lot of lawyers, and so far I think we've been fine. Some of the rural areas, we're running out of lawyers willing to do the work, quite frankly, or the lawyers who do it, and they're wonderful people and they care, but we have lawyers doing high-level felonies who never tried a case in their life because people with more experience have said, I'm sorry, I really can't do this anymore. So we need to keep pounding the drums, and I'm happy if you call me at my office to talk to you about what you can do personally. We have templates for op-eds. We have a template PowerPoint. If you want to give a speech to a local group, I'll give it to you. I'll talk you through it. Please, you've advocated for your clients for years all the time. You need to advocate for the system, and it's the time to do that is now. Okay? So thank you all. Any other questions? If you ever have a question about anything, feel free to call our office. Elisa, if she's there, will talk to you. I answer the phone and talk to people. People call and say, oh, I didn't think I'd get you. And I think, well, why did you call me? I'm happy to talk to you about issues. Oh, seriously, if you're ever in Durham, come by our office. We'll give you more bling. Seriously, thank you so much for the work you do.